This meeting is being recorded.
And there's the Zoom lady. All right, so Jeremy, do you want to kick things off?
Sure, Glenn. Hi, everybody. I hope everybody can hear me okay. We're just gonna, basically today, we're gonna run through the Code of Conduct. I almost called it the Model Code of Conduct because it used to be. And it's only been adopted, I think, in 2019. So it might still even be new to some people. And there are differences from the old CBA code if people are used to the old CBA code. And I didn't do any comparison, but I did look a little bit at the CBA code. And I can say that this new code is a lot more detailed and maybe a little more modern in some areas. So we're kind of going to go through it section by section. And like Glenn said, if there are questions or comments or discussion, feel free to throw it in the chat. We'd like to try to make it not too boring, though I'm not sure if that will be that easy to accomplish, to be honest. But and so if you have your codes, yeah, we'll just flip through. There's starts off with the preface. And I'm not going to read all that. I mean, you can read it as well. And I would note the last paragraph on the first page says that a breach of the provisions of the code may or may not be sanctionable. And there are some things in the code that are, I would say, maybe aspirational, but it's definitely a guide to follow. And then flipping on to the definitions at 1.1. This is, like I said, a bit more detailed than the CBA one when I went and looked. And a couple little things that jumped out at me were in the definition of client. It says that it also includes a client of the law firm for which the lawyer works, whether or not the lawyer handles the client's work. So I thought that was an interesting clarification. And there's also a definition of conflict of interest there, which I think is different from the old code. So I would point those out. And there's also a definition of law firm, and that includes lawyers practicing as a clinic under the Legal Aid Act, one or more lawyers practicing in a government, crown, corporation, or other public body. So that's probably relevant to some people on the call today. And with that, I think we flip over to Glenn. Oh, I think you're on mute, Glenn.
Sorry, Jeremy. Thanks. I am. Yep. So chapter
one of
2,
us was going to do it.
Chapter 2 it deals with integrity, and this is one of the most fundamental pillars, if you will, of the code. As lawyers, we have the duty to carry on the practice of law and discharge our obligations and responsibilities to clients, tribunals, courts, the public, and all other members of the profession honorably and with integrity. There's a dovetailing here of the provisions of the code with the provisions of the Legal Profession Act. If you look at commentary 3 talking about dishonorable or questionable conduct, that overlays with the definition of conduct unbecoming in section 22 of the Legal Profession Act, which is any act or conduct that is either harmful to the best interests of the public or the members of the law society, or that tends to harm the status of the legal profession generally. The acting with integrity includes such things as not throwing around your legal title. Do you know who I am? I'm a lawyer, therefore ... That arguably is a breach of the code. The only other point I wanted to touch on with respect to chapter 2 is 1.2, which is, as Jeremy said, aspirational. This is an encouragement for lawyers to be involved in the community more broadly. When you look at the commentary, it talks about lawyers are encouraged to enhance the profession through activities such as, and I'll pause at C, filling elected and volunteer positions within the society. That's something near and dear to my heart, particularly because we are forever trying to find people to fill society positions, but also to act as directors and officers, both for bar-related associations like the CBA, and as well society organizations within the broader society. And I pause to mention that all of us, when we're acting as directors on corporations, except publicly held corporations, are covered by directors and officers insurance, which the Law Society has in place as a method of encouragement to encourage you to engage in that activity. One final note, those of you that are employed, however, may want to check with your employer to make sure whatever extracurricular activities you're going to be taking on are allowed by that employer, because some employers have some prohibitions around extracurricular activities. I'm going to then turn to 3.1, competence. And I'm going to speak about the competent lawyer, which is 3.1-1. I'm not going to read it to you, but I would encourage you all to review it. I want to focus on a couple of things. I want to focus on section D, which is communicating at all relevant times of a matter all relevant stages of a matter in a timely and effective manner. If I was to identify a top 3 reasons why we get calls, number 1 or 2 would be my lawyer is just not responding to me. My lawyer is not answering my emails. And invariably what happens is I or somebody else at the Law Society contacts the lawyer and says, Jeremy Walsh is complaining that you're not returning his calls. And voila, the client calls the lawyer. It shouldn't need to be that way. I wanted to bring your attention as well to 3.1-2 and particularly commentaries 4, 4A, and 4B. 4 makes the point that depending upon what you're doing, you may need a particular degree of expertise in a particular area. In other situations, you may not. 4A and 4B are new commentaries that deal with lawyers needing to make sure they can not only understand, but use the technology that's relevant to the area that they're practicing in. This is important, and a demonstration of that we're seeing right now as we field calls from lawyers who are unable to navigate through the online renewal process. Commentary 5 talks about the necessity of being competent and being comfortable in being able to take something on. Many's the time when young lawyers particularly will take a project on because it's interesting, because they're doing it for a friend, because they don't have enough work to do, only to discover that they're way outside your depth. And the code specifically addresses that. Sometimes the best files are the ones that you don't take on because you're just not simply competent to do them. There's a number of other commentaries there that I'm not going to talk about, except for commentary 15, before I pass it back to Jeremy. And that is, being a competent lawyer doesn't require a standard of perfection. Mistakes happen, accidents happen. If you make an error, that doesn't mean that you're competent, that you're incompetent. However, as the commentary notes, if there's a string of errors or evidence of gross neglect, that may be another matter indeed. All right, Jeremy, quality of service, over to you.
Thanks, Glenn. Yeah, I think quality of service probably has some overlap with some of the remarks that Glenn just made as well. I think one of the key ones in there I see is probably the communication. If you go down to commentary 5 under quality of service, there's quite a few examples of expected practices, and a great number of them relate to communication, keeping the client reasonably informed, responding to phone calls, all those sorts of things, which goes further to what Glenn had said. And then commentary 6 as well notes a lawyer should meet deadlines and stresses the importance of promptness. And moving on from that, there is a discussion of limited scope retainers. And again, on the communication side, the commentary talks about making sure that the retainer is very clear, that it's all in writing. And I don't actually know if those kind of retainers are that common here, but you should know that it is in the code. One that is applicable, I think, commentary 5 under limited scope retainers says that this rule does not apply to situations in which a lawyer is acting as duty counsel. So that may be relevant to some folks on the line. And then moving on to 3.2-2, honesty and candor. Of course, when advising a client, a lawyer must be honest and candid and must inform the client of all information known to the lawyer that may affect the interests of the client in the matter. Again, this is going back to communication, it seems like. And under that section, there's a couple of interesting commentaries. I'd point out number 3 that talks about being firm with a client and says that a lawyer can be firm with a client, and it's not necessarily a violation of the rule. So I will point that one out. And commentary 4 as well, I'll note, has some specific content towards the Office of the Children's Lawyer. And there are a few sections in the rules that are relevant to the children's lawyer. And commentary 4 says a lawyer may withhold information from a client if the information is such that would present a risk of some emotional harm. And moving on to language rights, a lawyer must advise a client of their language rights, including the right to proceed in the official languages of the client's choice. And in the commentaries, it notes as well that there may be requirements as well in the criminal code or the charter to be aware of, depending on what kind of proceeding you are undertaking. And as well, I'll note that under 3.2(2)(b), it says that a lawyer must not undertake a matter unless the lawyer is competent to provide the required services in that language. And I think that's an important one to note, because I know there's been situations in the past in the criminal court anyway, where a person needed a lawyer that spoke French or some other language, and that always presents difficulties. So people may be tempted to sometimes do things maybe they aren't quite competent to do. And moving on to the next section, talks about when a lawyer acts for a organization, and says that although a lawyer may receive instructions from an officer or employee, the lawyer must act for the organization as a whole and exercising his or her duties. So I thought that was kind of an interesting section. And the next section talks about encouraging compromise or settlement. This is 3.2-4. And of course, the lawyer must advise and encourage a client to settle a dispute where possible, of course, on a reasonable basis. And I'd also point out the second part of that rule says the lawyer must discourage the client from commencing or continuing useless legal proceedings. So that's one to keep in mind as well. And moving on to 3.2-5, says a lawyer must not threaten to initiate a criminal charge or make a complaint to a regulatory authority to gain a benefit for a client. And I would note reversely too that commentary 2 says it is not improper to notify the proper authority of criminal or quasi-criminal activities while taking other steps through the civil system. So I would point that out. So it's just using it for the benefit of your client or to gain some strategic advantage that seems to attract the rule. And the next section is 3.2-6, inducement for withdrawal of criminal or regulatory proceedings. And that says that a lawyer must not give or offer any consideration to a person to influence the Crown, I guess, and or wrongfully influence any person from to prevent the Crown from proceeding with charges. And I would note that there was a lawyer in New Brunswick that fell afoul of this particular section, and he ended up being charged with obstruction of justice under the criminal code, in addition to law society difficulties. So that's definitely something to keep in mind. And in the commentaries flesh that out a little bit as well about dealing with kind of these parallel proceedings. And I guess the takeaway is just to be cautious and not try to induce anyone to do anything there. And I think it's over to Glenn then.
Thanks, Jeremy. All right, 3.27 and 3.28 talk about dishonesty and fraud. A lot of this stuff I appreciate is trite. We must never assist or encourage any dishonesty, fraud, crime, or illegal activity, or do or not do anything that could assist in dishonesty, fraud, crime, or illegal conduct. The commentary talks about lawyers unwittingly getting involved in things like mortgage fraud or money laundering. Some of you are familiar with the inquiry, the Cullen inquiry that's going on in British Columbia into money laundering, and there's been an awful lot of evidence there around money laundering in British Columbia and the role that lawyers played or did not play in that. And we can expect that come the fall, when the Cullen Commission report comes out, there will be some commentary around that. You'll know as well that parallel to this, the Federation of Law Societies has been working to beef up the money laundering and terrorist financing provisions. We rolled out new rules around that in, I believe, 2020, 2019, and there may be more changes coming. This is an area that has got the attention of the federal government in order to make sure that Canada continues to comply with its international obligations. And because lawyers are an exception, that means that the Federation of Law Societies has to make sure that we are keeping up with the requirements that the federal government is imposing on other people. The 328 talks about being retained by an organization and the organization acting improperly or acting fraudulently. Again, the same rules apply. It's not enough to say that, well, I'm just acting for the organization. If the organization is acting dishonestly, fraudulently, criminally, or illegally, you have an obligation. Similarly, you have an obligation not to involve, including if you're not doing anything that would allow for the organization to be doing something. Commentary 5 concludes with the commentary that in a situation like this, your only recourse may be to withdraw. And withdrawing means if you happen to be involved with the organization as well, also resigning your position with the organization, not just simply failing to act. 329 talks about dealing with clients with diminished capacity, and Jeremy touched on this a little earlier. This section fleshes it out. You have to do whatever you can when you're dealing with a client with diminished capacity to maintain a normal solicitor-client relationship, bearing in mind the limitations that your client might have. And commentaries 6, 7, and 8 are specific to the NWT and deal with obligations if you're acting for children and obligations that have come from the Office of the Children's Lawyer. 3.3 now talks about confidentiality, and back to Jeremy. And Jeremy, you're on mute now.
Yeah, sorry, I think I lost my page here a little bit, or I jumped ahead. Yeah, so 3.3 talks about confidentiality and the various requirements around that. And 3.31 has 4 little, I guess, exceptions to confidentiality, which are where expressly or impliedly authorized by the client, required by law or a court, required to deliver the information to the Law Society, or otherwise permitted by this rule. So there's kind of 4 little things there to keep in mind. And then under the commentaries as well, of course, number 1 talks about why the confidentiality is so important that a lawyer cannot render effective service to a client unless there's full communication. And moving down, it talks about at number 5. It says generally a lawyer should not disclose having been retained by a person about a particular matter or consulted by a person about a particular matter as well. And number 6 talks about a lawyer should take care to avoid disclosure to one client of confidential information concerning or received from another client, and should decline employment that might require such disclosure. Moving down to number 8 as well, I'll highlight, says a lawyer should avoid indiscreet conversations and other communications, even with the lawyer's spouse or family, about a client's affairs. And I always point that one out when we do this one, just because it is in a town like this, people learn things in unexpected ways. And the commentary goes on to say part of the reason for that, aside from the confidentiality of the client, is just the respect of the listener for lawyers and the legal profession. If they hear people talking about things that should probably be confidential. And moving down to 3.3, use of confidential information, says a lawyer must not use or disclose a client's confidential information to the disadvantage of the client or former client, or for the benefit of the lawyer or a third person without the consent of the client or former client. So it's not an absolute bar, but again, it talks about consent. And I think consent is actually defined back in the definitions as well. So you should look at that definition. And 3.3 says a lawyer may disclose confidential information, but not more information that is required when the lawyer believes on reasonable grounds that there is an imminent risk of death or serious bodily harm, and disclosure is necessary to prevent the death or harm. And commentary notes that these situations will probably be extremely rare. I can't really think of I mean, I probably can think of a scenario, but I think it's probably pretty rare. But I should note that this is in there. And commentary 3 has a list of factors to consider if you're in a position where you may have to make such a disclosure, such as the likelihood that the potential injury will occur, absence of other feasible ways to prevent the injury, and circumstances under which the lawyer acquired the information. And as well, I'd point out commentary 5 as well recommends that if you do make such a disclosure that you immediately prepare a note to self or a memo to yourself setting out the date and time and the grounds and the reasons you made the disclosure. So I thought that was kind of interesting as well. And 3.34 has certain exceptions where a lawyer may disclose confidential information if it is to defend against allegations, if it is alleged that the lawyer has committed a criminal offense, is civilly liable with respect to a matter involving a client's affairs, or have committed acts of professional negligence or acts of professional conduct. As well, 3.35 allows for disclosure of confidential information in order to establish or collect fees. And as well, 3.36 allows for disclosure to another lawyer to secure legal or ethical advice about the lawyer's proposed conduct. And as well, 3.37 allows for some disclosure to the extent necessary to detect conflicts and deal with conflicts of interest. So there are a few little exceptions there to the confidentiality. And I think it's over to Glenn then. Sorry.
Thanks, Jeremy. All right, we're shifting now and talking about conflicts. Conflicts is something that lawyers, certainly in private practice, deal with every time they pick up the phone. And it's a relatively detailed description that you're going to find in the code. The baseline rule is that you can't act or continue to act for a client if there's a conflict of interest, except where permitted by the code. So there are several kinds of conflicts. The commentary talks first about the bright line test that the Supreme Court of Canada has enunciated, where you can't act for one client whose legal interests are directly adverse to the immediate legal interests of another client, even if the matters are unrelated. But that's just one part of it. Another part of it is there's a conflict of interest where your representation of a client would be adversely affected by your own interests or by the duties you have to another client, to a former client, or to a third person. It's important to recognize that we are treated as fiduciaries, right? We have a fiduciary duty to our clients. And because of that, our obligations become much higher. Commentary 7 talks about the fact that just because the file is closed doesn't mean that your fiduciary duty or your duty of confidentiality is extinguished. You continue to have a duty of confidentiality and a fiduciary duty to former clients as well. And you want to be careful when you have a conflict, or when you potentially have a conflict, in making sure that you're forthright and upfront with your client right from the start. If you have a situation which you don't think is a conflict, but the client might, prudence suggests that you flag that for the client right off the bat. I want you to know that I also act for ABC. I act for ABC in an entirely unrelated matter. I don't believe it's a conflict, but I want you to know that I act for ABC. And if you have any concerns about that, then perhaps you should find somebody else. It's important as well, and this starts off, this is identified rather in commentary 10, where you might not have a conflict of interest at the start of a file, but as the file progresses, you may discover that something has evolved in the file where you have a conflict of interest, or one of your partners or associates may have taken on another client, which generates a conflict of interest. It's not enough to just simply look at the question of conflicts at the start of the file, but also on an ongoing basis to make sure that circumstances haven't changed such that where there was no conflict, there is now. Commentary 11 identifies a number of areas where possible conflicts could arise. And I note that there are 6 or 7 there, but the drafters make the point that this is not an exhaustive list. But it talks about where you're acting for someone and giving advice about a client that you act for in another matter. You're providing advice to a business at the same time providing advice to the employee of the business on unrelated matters. Where you have you or somebody in your firm or somebody in your family has a financial stake, either in the client or in the opposing party, such that it may create a perception that you're not able to give the client the best attention and direction possible. Where you have a sexual or close personal relationship with a client. We have specific language about that we're going to get to in a little bit. And you need to know as well, and we'll talk about this later, that the code is going soon to be beefed up around the areas of harassment and discrimination, because issues of lawyer-lawyer conflict have moved to the Law Society from the Human Rights Commission. And there are a great many of those situations presently now being considered by other law societies. And as a result, the code of conduct language around discrimination and harassment is being beefed up. Acting for a corporation in which you serve as an officer or a director. And finally, when you look at category G, acting for more than one party at a tribunal. This is language that's unique to us. And it's something that the LEAP committee considered last year in response to specific issues that were raised to the Law Society by members. You'll see commentary 13 talks again about the role of somebody who's acting for a child and specific provisions there. 3.4-2 talks about consent. Now, 3.4.2 talks about representing a client in a matter which is contrasted with representing a client in a dispute. You can never act on both sides of a dispute. You can, however, represent a client in a matter where there might be a conflict of interest if you get consent from the client, and consent, in fact, from all clients. And the lawyer believes that they can act without their representation of others being impinged. What are the elements of consent? First, there needs to be disclosure. You need to have a full and frank discussion with your client and disclose all the issues that could give rise to a conflict. And you need to allow the client time to make an independent and informed decision. The commentary notes that while it may not be necessary for the client to go off and get independent legal advice, you may very well want to recommend that the client do that so that there can be no suggestion going forward that you didn't allow the client the opportunity to do that, and that the client was somehow pressured. Because you got to anticipate the worst when you get into a situation like this. Commentary 4 talks about requesting consent in advance. And there are some firms who, as part of their general retainer letter, attempt to get clients to consent in advance to the firm taking on at a later date any other clients that might constitute conflicts of interest. As you can appreciate, that kind of advance consent is not necessarily going to be found to be valid because there's not the appropriate degree of disclosure that's there. And again, even if you are looking for consent in advance, you would be well served to suggest to the client at least that they get some independent legal advice. Commentary 3.4-2 talks about providing short-term summary legal services. This would, for example, be somebody who's working at the outreach clinic or providing some pro bono advice. And there's an exception to the conflict rule there where you're providing short-term summary legal services. You're allowed to do that without taking the steps to determine whether or not there is actually a conflict of interest. But even when you do that, the commentary goes on to make it clear that you have an obligation to make sure that whatever information you get, even in those circumstances, is kept confidential and nobody else can access it. I want to turn next to 3.4-3, which is a conflict of interest in dispute. You recall I contrasted disputes from other circumstances. And Rule 3.4-3 is quite explicit. Despite Rule 3.4-2, a lawyer must not represent opposing parties in a dispute, even with consent. You cannot do it. Rule 3.4-4 talks about concurrent representation. And if you are acting for two different parties in a circumstance, in an event, the necessity that you make sure that you maintain the appropriate screens such that information from you isn't going to accidentally bleed out to the lawyer who's acting for somebody else, because then there's a breach of the confidentiality issues. Joint retainers is talked about in 3.4-5, and joint retainers, for example, you're acting for both borrower or purchaser and seller, and the obligations are spelled out there about making sure that you disclose to both clients that you're acting for both, making sure that everybody understands that you'll continue to do that as long as everybody's interests are aligned. But if there is a dispute, you're going to have to send both clients away, not one, but both. You can't pick which horse you're going to ride if you're acting for both buyer and seller. You have to send them both away in the case of a dispute. Commentary 2 talks about joint wills and taking instructions there and specific provisions around that. And again, there's commentary there dealing with acting for children that's come from the Office of the Children's Lawyer. 3.48 talks about the referring out of clients in the event that you've got a joint retainer. And 3.49 says if clients consent to a joint retainer and also agree that if a contentious issue arises, the lawyer may continue to advise one of them. You can do that and then refer the other out. However, I suggest that's not particularly good practice. And I'm not confident that you could paper that well enough, that if the contentious issue revolves into something more, that you're going to be able to protect your own hide there. Jeremy's now going to talk about acting against former clients.
Yeah, so 3.410 deals with acting against former clients. Not surprisingly, it says it's not a really good idea, and lawyer must not act against a former client in the same matter, any related matter, any other matter. If the lawyer has relevant confidential information arising from the representation, unless the former client consents, which I couldn't really think of a scenario where they would consent. So I don't know if that will work, but I think this one's important up here too, because it's the conflicts generally, it's so small, and then in this one too, I mean, the questions become, if you have somebody on duty counsel for a bail hearing, can you then sue them for their mortgage default? Like, it's not necessarily a related matter, but these kind of things that probably do come up in this jurisdiction for sure. And the other exception to that, I guess, is 3.4 sub 11 says when a lawyer has acted for a former client and obtained confidential information relevant to a new matter, it says another lawyer in the lawyer's firm may act in the new matter against the former client if the former client consents to the other lawyer acting, and the law firm has taken measures to ensure there will be no disclosure of the former client's confidential information. So I guess that's one way to manage that. I think the issue here sometimes we struggle with is not many lawyers, and then you've acted for a lot of people. So I guess there are some ways maybe to manage that a little bit. 3.4 sub 12 talks about acting for borrower and lender. I don't know why I can't say that today. It says a lawyer must not act or otherwise represent both lender and borrower in a mortgage or loan transaction. Again, there is some flexibility in that in certain circumstances. And I would point out that in 3.4 sub 14, it says provided there's compliance with this rule, and 3.45 to 3.49 dealing with conflicts, a lawyer may act or otherwise represent both lender or borrower if the lawyer practices in a remote location where there are no other lawyers that either party could conveniently retain for the mortgage or loan transaction. So I thought that was kind of an interesting exception to that. But again, as with any of these exceptions, tread carefully for sure. Moving down, 3.4-17 talks about conflicts from transfer between law firms. And I wasn't going to go too far into that. I think some of that might have been covered in other sections as well. And the commentaries as well talk about what is required for knowledge. And again, they refer to the Supreme Court of Canada in McDonald Estate, the 1990 case, which is always a good one to keep in mind. And it also talks at commentary 3 about law firms with multiple offices, and says that this rule treats as one law firm such entities as various legal services units of a government, a corporation with separate legal departments, and an interjurisdictional law firm. So I thought that was kind of interesting as well. And 3.419 says that this rule or rules 3.420 to 22 do not apply to a lawyer employed by the federal or a territorial government who, after transferring from one department to another, continues to be employed by that government. So I thought that was kind of interesting because we often think of the private law firms, I guess. So, and 3.420 says if transferring lawyer actually possesses confidential information relevant to a matter respecting the former client that may prejudice the former client if disclosed to a member of the new law firm. The new law firm must cease its representation of its client in that matter unless the former client consents or the new law firm has taken reasonable measures and has advised the lawyer's former client. We keep seeing these references to consent throughout the code. So maybe that's a question to ask yourself on any of these things: is do I need consent of the former client? And let's go down. And at commentary 3 has some guidelines as well about, I guess, how to create a screen or how to avoid the exposure of the new lawyer to the information the new lawyer has, how to avoid kind of that being transferred. So definitely keep that in mind as well. And there's also some commentary at 4 and 5 about how to determine if a conflict exists before maybe hiring a lawyer that's coming from another firm. And 3.421 talks about the new transferring lawyer, and that they are disqualified or must not participate in any matter in the new firm's representation of the client unless the former client consents. And I think that's over to Glenn then.
Thanks, Jeremy. Yeah, we drew the lines. We should have, I should have given you the next one as well, because 3.4-23 essentially provides that you have to do the same kind of diligence as you would do for a lawyer if you are hiring staff. So you should, if you're bringing staff over from another firm, you have to take the same precautions to make sure that when the staff come, they're not bringing any information with them. There's a comment here that says 3.4-2 and 3.4-3 don't carve out exceptions for lawyers acting as mediators in divorce family cases. If such a lawyer obtains a consent retainer from the former spouses at the outset of mediation, prior to financial disclosure being exchanged or any obligations discussed, how can that satisfy the requirement to ensure that the consent is fully informed and voluntary after disclosure? I think you're going to find that we'll talk a little bit about that when we get to the lawyer as a mediator later on, and I think we might find the answer there. I'm now going to shift and talk about doing business with a client. So I'm going to pick it up at 3.4-27. There are definitions there, definitions about independent legal advice and independent legal representation. The fundamental rule begins at 3.4-28. A lawyer must not enter into a transaction with a client unless the transaction with the client is fair and reasonable to the client. Remember, this isn't fair and reasonable to both parties. If there's a dispute, the court's not going to side with you, it's going to side with the client. So is this fair and reasonable to the client? And the rules go on to suggest that if you're going to be doing that, and the rule goes a long way towards trying to dissuade you, but if you're going to be doing that, consider whether or not the client needs to get independent legal advice, and make sure that you get this papered and consented all the way through. There's an exception in 3.4-30 where the fair and reasonable provisions don't apply, where a client intends to enter into a transaction with a corporation or other entity whose securities are publicly traded, or where the lawyer borrows money from a client that's a bank, trust company, insurance company, credit union, or finance company that lends money in the ordinary course of business. Commentary again reminds us about our fiduciary obligations. And commentary 4 makes the point I made just a little bit earlier. Generally, in disciplinary proceedings under this rule, the burden will rest upon the lawyer to show good faith, that adequate disclosure was made in the matter, that independent legal advice was received by the client where required, and that the client's consent was obtained. I think you should be very careful if you're going to enter into a business transaction with your client, and prudence may suggest that you might want to give it a pass. Commentary 5 over the next page talks about the necessity of documenting the independent legal advice. 3.4-31 talks about borrowing from clients. You must not borrow from a client unless the client is a lending institution or the client is a related person to the lawyer as defined by the Income Tax Act, and the lawyer discloses and the lawyer requires that the other party get independent legal advice. Similarly, 3.4-33, a client must not lend money, or sorry, a lawyer must not lend money to a client unless before making the loan, the lawyer discloses and requires that the client receive independent legal representation, or if the client is a related person as defined by the Income Tax Act, receive independent legal advice and consent is obtained in all cases. There's provisions around guarantees. If you're acting for a client in a transaction, you ought not to be guaranteeing personally any indebtedness of which the client is the borrower or lender. And 3.4-35 talks about when you can give personal guarantees, and 3.4-36 provides an exception to that rule. 3.4-37 through 39 talk about receiving benefits through a will. A lawyer must not accept a gift that's more than nominal from a client unless the client's received independent legal advice. A lawyer must not include in a client's will a clause directing the executor to retain the lawyer's services in the administration of the client's estate. And unless the client is a family member of the lawyer, a lawyer must not prepare or cause to be prepared an instrument giving the lawyer a gift or benefit from the client, including a testamentary gift. The final section in this area deals with bail situations. You must not act as a surety or deposit money or securities as part of a bail process. Finally, 3.4-42 and 3.4-43 are again sections that are unique to the NWT, and they require that lawyer must maintain professional boundaries in any interaction with a client, and a lawyer shall not enter into a sexual relationship with an existing client unless a consensual sexual relationship existed between them when the lawyer-client relationship commenced. Jeremy, preservation of client's property.
Yeah, I think a lot of this is probably section is probably fairly common sense. Just talks about preserving the client's property and returning the property to them. I will note, I think as part of the discipline committee, I've seen one complaint that maybe involved this to some extent. So definitely something to keep in mind as well if clients are asking for their documents back and things like that. I'd also point out 3.5.3 requires a lawyer to promptly notify a client of the receipt of any money or other property of the client unless satisfied that the client is aware that they have come into the lawyer's custody. And I presume that to mean settlement funds or disbursements or things of that nature. So definitely keep that one in mind. And again, that seems to go back to a lot of these go back to the communication piece that we talked about earlier on. So that seems to be a trend throughout the new code. And 3.54 to 3.57 also talk about identifying the client's property and maintaining records of any property that are held. And as well. I would note commentary 1 as well. Talks about privilege under 3.57, talks about where there's claims of privilege over property seized, and by any external authority or in respect of any third-party claims made against the property. In particular, it mentions the Income Tax Act. And the next section, 3.6, is fees and disbursements. And 3.61 says lawyer must not charge or accept a fee or disbursement unless it's fair and reasonable, has been disclosed in a timely fashion. And commentary 1 has a useful summary if people are looking at what a fair and reasonable fee is. Of course, time and effort spent, the difficulty, results obtained, any agreement between the lawyer and client, the experience of the lawyer, all of those kind of things. The lawyer or the client's prior consent to the fee as well. And commentary 2 talks about full disclosure of any matters related to fees. And going down, commentary 3 again says the lawyer should provide to the client in writing as much information regarding fees and disbursements as is reasonable, including the basis on which the fees will be determined. And commentary 4 again says the lawyer should be ready to explain the basis of the fees that were charged. And going down to 3.6-2, we're into contingency fee agreements. And that rule says, subject to 3.6-1, a lawyer may enter into a written agreement that provides that the lawyer's fee is contingent in whole or in part on the outcome of the matter for which the services are provided. So that is permissible. And commentary 1 has some guidance on determining the appropriate percentage or other base of the contingency fee. And it's some of the same factors noted above, the nature and complexity of the claim, the expense and risk of pursuing it, the amount of the expected recovery, likelihood of success. And it says as well, the test in all circumstances is going to be whether the fee is fair and reasonable. I guess whether it's a contingency or just a straight billing, that's going to be always going to be the test. And I'd point out as well that commentary 2 sets out some, I guess, talks about withdrawing under a contingency agreement, and just says there may be some other factors at play there, and some of the other reasons for withdrawing around fees may not apply where the lawyer has basically taken on the risk of not being paid. And says that the lawyer can only withdraw for the reasons set out in 3.77, which we will get to, unless the written contingency agreement contract specifically states that the lawyer has a right to do so and sets out the circumstances under which this may occur. So that might require some foresight or some drafting. And again, it's this consent and communication part again. And 3.6 sub 3 talks about the fact that the lawyer must clearly set out in their account all the amounts charged as fees and disbursements. And going on, 3.6 sub 4 talks about joint retainers for where a lawyer is acting for 2 or more clients. It says that the any fees and disbursements must be divided equitably between them unless there's an agreement otherwise. So I would point that out. And as well, 3.65 and 3.66 talks about splitting fees between lawyers who are not in the same firm, and says that may be done as long as there's consent from the client and the fees are divided in proportion to the work done. 3.66 talks about referral fees. I don't know how common that is here. I've never really heard of that. But if you do that, that is in the covered in the rules here. And then at 3.6 sub 7, however, says that a lawyer must not split or indirectly share or divide his fees with any person who is not a lawyer, and must not give any financial or other reward or a referral fee to any person who is not a lawyer. So I would point that out as well. And then under the commentary as well, it expands on that a little bit as well. Going down, 3.6 sub 8 says that this rule 3.67 does not apply to multidiscipline practices. I don't think that's an issue in our jurisdiction. And as well, it is interesting, 3.6 7 does not apply to sharing of fees by lawyers who are members of an interjurisdictional firm. So I thought that was kind of interesting as well. 3.69 talks about the payment of funds, and talks about appropriating client funds that are in trust, and says a lawyer must not appropriate any client funds held in trust except as permitted by the governing legislation. So you'll have to go back to, I guess, your individual jurisdiction's requirements to see what those are. And 3.612 talks about prepaid legal services plan, which I don't know if that, I've never heard of that in this jurisdiction either, but it is in there if that's something that you are looking at. And that would be over to Glenn.
Thanks, Jeremy. 3.7, withdrawal from representation. When you take a client on, you need to be assuming that you're going to have that client through till the end of the process, whatever that process may be. And Rule 3.7-1 makes that point. You must not withdraw from representation of a client except A, for good cause, and B, on reasonable notice. The commentary goes on to beef that up. The last line of commentary 1 says that it's inappropriate for a lawyer to withdraw on capricious or arbitrary grounds. You need to have good cause. And you need to give reasonable notice. And we'll talk a little bit about notice later on. So what is good cause? A long time ago, I was told by someone much senior to me that if you're in a situation where you're starting to have doubts about your client, what you want to be doing is you want to be documenting that. And you want to be documenting that you're starting to lose confidence in your client. The reason you're doing that is because when you look at Chapter 37-2, you can withdraw if there's a serious loss of confidence between the lawyer and the client. So Monday, you can't be going full bore, and Tuesday saying, I've completely lost confidence in you, so I'm withdrawing. But if the relationship is evolving and not evolving in a right way, you want to be documenting that. And you might also want to be saying to the client, listen, I'm starting to lose confidence in you because, it may end up that I end up having to withdraw later on. You can, of course, as well, withdraw if the client fails to provide you with fees or fails to pay your accounts, unless serious prejudice would occur to the client. So if the client has not paid you and you're on the eve of trial, you cannot then say the day before the trial, you haven't paid me, I'm withdrawing. That would absolutely create serious prejudice to the client. So if you're in a situation where you're not being paid, deal with that sooner rather than later, because you may not be able to deal with it later. Rule 37-4 talks about specific provisions with respect to criminal proceedings and makes the point that if you are withdrawing because you haven't been paid, that's not necessarily something that you disclose to anybody. You just simply say that you're required to withdraw. And 3.75 talks about the situations where you may be required to continue to represent even if your fees aren't being paid. If there is serious prejudice or if there's not appropriate time for the client to find another lawyer. 3.77 talks about when you are required to withdraw. You are required to withdraw if your client discharges you, if you're fired by your client. You can't deny that. The client chooses the lawyer. If the client fires you, then you are fired. If the client persists in instructing you to act in a way that's contrary to ethics, or if you're not competent to continue to handle a matter. The third one causes some difficulties because if you weren't competent to handle it, why did you take it on in the first place? I mean, it may be that in a particular situation, it's evolved such that you can no longer manage it, but I would think that would be few and far between. You are required to withdraw, though, if you get fired, or if your client is instructing you to act in a way that you believe to be contrary to professional ethics. In these situations, again, document, memo your file so that if there's any questions later on, you can go back to your file and say, this happened on the 2nd of March. The client asked me to do this and I wouldn't, and this is why I wouldn't. And this is the 15th time the client's asked me to do something like this, and therefore I withdrew. 3.7-7A talks about leaving a firm. This happens. Lawyers leave firms, lawyers go to other firms, and the friction that exists there exists often around who the client belongs to. The lawyer who's leaving is pretty sure that the clients belong to them, and the firm is equally sure that the client belongs to the firm. And the answer is that the client belongs to the firm, and the client stays with the firm unless the client says otherwise. So you'll see when you read through the commentary, they make the point that the client's interest is paramount. It suggests that where possible, the firm and the departing lawyer should jointly write a letter to the client, setting out to the client's options. The client's options are to stay with the firm. Another client option is to go with the departing lawyer. And yet another option is for the client to say, I don't want to stay either with the firm or go with the departing lawyer. I want to go somewhere else. It's important that that information get out to the clients be allowed to make an independent decision, and that everybody honor the decisions that the client made. There's an exception that this rule doesn't apply to a lawyer leaving a government, crown corporation, or any other public body, or a corporation for which the lawyer is employed as in-house counsel. Jeremy flagged a parallel provision earlier on. 3.7-8 talks about how you withdraw. If you're withdrawing, you have to minimize the expense and avoid the prejudice to the client. and do everything that you can do to facilitate the transfer of the matter to a successor lawyer. The commentary at 3.7-9 talks about things that the lawyer must do, including deliver to the client all the papers and property to which the client is entitled, subject, of course, to your right to exercise your solicitor's lien. If you haven't been paid, you're entitled to exercise your solicitor's lien against that property. However, when you look further down in the commentary, they make the point that you should not be enforcing your lien if to do so would prejudice materially the client's position in any uncompleted matters. You need to give the client their trust money back. You need to account for all the funds that the client's given you. You need to render your account right away for outstanding services up to the time of withdrawal. You need to cooperate with the successor lawyer. Now, that's cooperate with the successor lawyer when the file is transferred. That doesn't mean that forever and ever you're a resource for the successor lawyer who comes back to you and says, why did you do this? Why did you do that? You don't have to explain what you did. Your job, once you've withdrawn, is to get the file to the successor lawyer, explain where the file is with the successor lawyer. If the lawyer has any questions about the status of the file, answer them. But you're not an ongoing encyclopedia for ongoing matters. And finally, 3.7-10 talks about the duties of a successor lawyer. As a lawyer who's taking over a file, you should be encouraging the client to pay the departing lawyer's fees promptly. But if there's a dispute, you should then be telling the client how to go about getting that dispute resolved. And finally, the commentary makes the point that you shouldn't allow an outstanding account to get in the way of you proceeding with the trial or other proceedings that the client's expecting you to take on. All right, Jeremy, making legal services available.
Yeah, thank you. So section 4.1, making legal services available, says a lawyer must make legal services available to the public efficiently and conveniently. I could spend a whole lot of time on that, but I did note commentary 4 under that is kind of interesting. That's the right to decline representation. It says a lawyer has a general right to decline a particular representation, except when assigned as counsel by a tribunal, but it's a right to be exercised prudently, particularly if the probable result would be to make it difficult for a person to obtain legal advice or representation, which is probably often a consideration in our jurisdiction with the limited amount of lawyers sometimes. And as well, further down, it says a lawyer declining representation should assist in obtaining the services of another lawyer qualified in the particular field and able to act. I'm not sure how strenuous that is, if it's enough to refer somebody to another lawyer or to the Law Society referral list. But I would just note that that commentary, I guess, when you do, if you do decline to act for people. 4.1-2 says a lawyer must not use, in offering legal services, a lawyer must not use means that are false or misleading or amount to coercion or harassment. I think some of this might be covered under other rules as well. And 4.21 talks about marketing and the different factors for that. Marketing must be true, accurate, not misleading, not likely to mislead, and in the best interest of the public. And there's several examples at commentary 1 of different types of advertising that may go against this rule, such as raising expectations, suggesting or implying the lawyer is aggressive, and different things like that. Moving on to 4.3 sub 1, I thought this one was kind of interesting. It says a lawyer must not advertise that the lawyer is a specialist in a specified field unless the lawyer has been self-certified by the society. I know some jurisdictions, Ontario in particular, I know does certify people as specialists. Maybe some other jurisdictions do as well. And I would note that in the commentary, it talks about how you can use that designation in any advertising. And I would note as well, commentary 3 specifically relates to our jurisdiction, and it says of a firm practices in more than one jurisdiction, an advertisement by such a firm that makes reference to the status of a firm member as a specialist or expert in media circulated in the Northwest Territories and the certifying jurisdiction does not offend this rule if the certifying authority or organization is identified. And I just note that one because I think there's some people on the call that may practice in different jurisdictions. So I thought I would kind of note that one. And I think it's led over to Glenn.
Thanks, Jeremy. All right. Chapter 5, the lawyer as advocate. 5.1-1 identifies the teeter-totter that we ride when we're advocates. When acting as an advocate, a lawyer must represent the client resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect. Those are the two edges to the sword. Commentary 1 makes the point that the lawyer has a duty to raise fearlessly every issue, advance every argument, and ask every question, however distasteful, that the lawyer thinks will help the client's case, and to endeavor to obtain for the client the benefit of every remedy and defense authorized by law. It then goes on to say you have to do this by fair and honorable means. But there's nothing in the code of conduct that says that you are not to be an aggressive and, in the words of the code, a fearless lawyer. However, being aggressive and being fearless can coexist with being respectful to the court or other tribunal that you're appearing in. The commentary goes on to suggest that these same rules apply not just to courts, but to other tribunals. Acknowledges that your role as an advocate is partisan and is recognized as partisan and is expected to be partisan. Commentary 6, I want to spend a little bit of time on, because those of you who practice in particular areas of law where there's a lot of self-reps will encounter this all the time. When opposing interests are not represented, for example, in without notice or uncontested matters, or in the case of self-reps, the lawyer must take particular care to be accurate, candid, and comprehensive in presenting the client's case, so as to ensure that the tribunal is not misled. There's nothing here that says you don't cease to be fearless. You don't cease to be resolute. However, you do have to be particularly comprehensive and candid when the other side is not represented. Commentary 8 says you should be encouraging your client and you should be avoiding engaging in proceedings that are frivolous and vexatious, that are meant to delay, that are meant to take advantage, and that aren't looking to actually advance the matter. And it makes the point that such practices can bring the administration of justice into disrepute. There's language in the commentary about what you're to do as defense counsel. There's language in the commentary about admissions. And at paragraph 11 of the commentary, again, there's particular language around the expectations of someone who's acting for the office of the children's lawyer. 5.1.2 has the will nots. When you're acting as an advocate, you won't abuse the process. You won't permit or allow your client to do anything that's dishonorable. You won't allow anybody directly or indirectly to influence the decision making by the tribunal or the tribunal's decision makers. You're not going to misstate any documents that you're bringing forward. You're not going to attempt to deceive a tribunal directly or indirectly. You're not going to deliberately refrain from informing a tribunal of any binding authority that you consider to be directly on point and that has not been mentioned by somebody else. And I'll touch on this again. Jeremy touched on it earlier. Commentary N when representing a complainant, you won't attempt to gain a benefit for the complainant by threatening the laying of criminal or quasi-criminal charges or complaints to a regulatory authority, or by offering to seek to procure the withdrawal of a criminal or quasi-criminal charge or complaint to a regulatory authority. I believe that's also an offense under the criminal code. Rule 5.1-2A goes on to talk about incriminating physical evidence. You must not counsel or participate in the concealment, destruction, or alteration of incriminating physical evidence, or otherwise act so as to obstruct or attempt to obstruct the course of justice. Those of us who've been around a while may remember a relatively high-profile case in Ontario where there was a concern about a defense lawyer doing exactly that. The commentary says at paragraph 2, this rule does not apply where a lawyer is in possession of evidence tending to establish the innocence of a client, such as evidence relevant to an alibi. But you've got to use prudent judgment in determining whether this evidence is wholly exculpatory and therefore falls outside of the application of this rule. If it's not, then you might need to be doing some thinking about whether or not you have a duty to disclose it. You should never take into possession incriminating physical evidence from your client. You're not required to do that. Commentary 5, the lawyer has no obligation to assist the authorities in gathering physical evidence of crime, but as well, you're not to be acting or to be advising anybody to hinder the investigation by the authorities. Rule 5.1-3 talks about the duties of a prosecutor. And the commentary makes it clear when engaged as a prosecutor, the lawyer's primary duty is not to seek to convict, but to see that justice is done through a fair trial on its merits. 5.1-4, if you're aware of an error, if you've unknowingly done or failed to do something that, if done or omitted knowingly, would have been a breach of this rule and you discover it, you must, subject to section 3.3, which deals with confidential information and confidentiality, disclose the error or omission and do all that you can reasonably do to rectify it. 5.1.5, you must be courteous and civil and act in good faith to the tribunal and all persons with whom the lawyer has had dealings. This, I know, can become particularly difficult where you're dealing with self-represented people, particularly aggressive self-represented people. However, remember, you do have this duty. 5.1.6, you must strictly and scrupulously fulfill any undertakings given and honor any trust conditions accepted in the course of litigation. On the question of civility, I will mention that the practice advisor is coming up later this year to talk about civility, and Eugene Meehan from Supreme Court Advocacy will also be putting on a session on civility later this year. That's it. 5.2, lawyer as a witness, Jeremy.
Yeah, so section 5.2 says a lawyer who appears as an advocate must not testify or submit his or her own affidavit evidence before the tribunal unless permitted to do so by law, the tribunal, or the rules of court, or unless the matter is purely formal or uncontroverted. And commentary goes into that as well and says a lawyer who for some reason is a necessary witness should testify and entrust the conduct of the case to another lawyer. And as well, 5.22 says a lawyer who is a witness in proceedings must not appear as an advocate in an appeal from the decision in those proceedings. I don't know, that comes up a whole lot, but it's definitely an interesting one. And then I think we roll into 5.4, communicating with witnesses. And 5.4 sub 1 says a lawyer may seek information from a potential witness, but must, of course, disclose the lawyer's interest in the matter, must not encourage the witness to suppress evidence, and as well must be aware of rules related to communicating with represented parties, which appear a little farther down in the code at commentary 1, there's the statement, there's generally no property in a witness, which is probably a trite one. But it does say a lawyer should not advise a potential witness to refrain from speaking to other parties except as provided in this rule. So I thought that was interesting direction as well. Commentary 2 highlights special considerations may apply, of course, with expert witnesses. And you may get into issues of privilege or litigation privilege there. So just be aware of that. 5.42 to 5.43 talks about preparing a witness, that a lawyer must not influence a witness to give evidence that's false, misleading, or evasive. And as well, a lawyer involved in a proceeding must not obstruct an examination or cross-examination in any manner. And in the commentary as well, at I think it's commentary 3 to 7 there, talks about communicating with witnesses under oath or affirmation. So definitely be aware of that. And of course, a lawyer may generally not communicate with a witness during cross-examination except with leave of the tribunal or with the agreement of counsel. And commentary 7 said a lawyer should seek approval from a tribunal before speaking with a witness after cross-examination and before re-examination. So it's good to be aware that all of these things are in the code. And as well, commentary 8 notes that Rule 5.4 about communication with witnesses also applies to examinations for discovery or examinations on affidavits. Just to be clear about that. And 5.5 talks about relations with jurors. And of course, a lawyer, when acting as an advocate in a case, must not communicate with or cause anyone else to communicate with anyone that the lawyer knows to be a member of a jury. And commentary 1 talks about that a lawyer may investigate a prospective juror, but must not directly or indirectly communicate with the juror or any members of the juror's family. And as well, 5.5 sub 2 talks about the duty of a lawyer to disclose to a tribunal any information which may come to light about that a juror has an interest in the outcome of a case, or is acquainted with or connected to the judge or counsel or any other lawyer, or is acquainted with anyone who is to appear as a witness. And as well, 5.5 4 reiterates that a lawyer acting as an advocate must not communicate with a member of the jury during a trial of the case. And as well, point out 5.55 says a lawyer is not connected with a case before the court must not communicate with or cause another to communicate with any member of a jury about a case. And as well, a lawyer must not have any discussion after trial with a member of the jury about its deliberations. And I'd point out as well that I think the criminal code makes an offense for a juror to disclose info related to proceedings as well. And I know I've had people say to me when they hear you're a lawyer that they have been a juror, and I sometimes will caution them not to say anything else about that. But I've never had anybody actually spill their guts about that. Though, of course, in the United States, they probably write a book about it. And I think we're on to Glenn.
Thanks, Jeremy. Right. The lawyer in the administration of justice. A lawyer must encourage public respect for and try to improve the administration of justice. The commentary makes the point that this is an obligation that we have 24/7. This isn't restricted to our professional activities, but every minute of every day, we have the obligation to try and improve the administration of justice. Well, what does that mean? That means that we should be trying to avoid criticism of courts, criticism of tribunals, criticism of court decisions. I'm paraphrasing from commentary 3, because in the eyes of the public, the fact that we're a lawyer means that our perhaps intemperate comments are given more weight than they ought to. Also, the commentary makes the point that if you've been involved in the proceedings, there's a risk that any criticism will be seen as partisan rather than objective. And finally, they make the point that courts and tribunals can't defend themselves. We have an obligation to defend tribunals and courts when they're being attacked in other quarters. And I know the Law Society occasionally does that. The Canadian Bar Association does that a lot more often. 5.6.2 talks about the necessity to disclose or advance any interest that you might have when you're seeking legislative changes. 5.6-3 talks about security of court facilities. And if I am allowed a little bit of levity, given what's been going on in Yellowknife recently, if you park underneath the courthouse in Yellowknife and you believe your car is going to explode, you ought to be reporting that to the authorities, because it appears that most cars under the park under the courthouse seem to explode. All right, 5.7 is next, lawyers and mediators. And this takes us into one of the questions that came up in the chat later. The rule is that if you're acting as a mediator, you must at the outset ensure that the parties understand that you're not acting as a lawyer, but you're acting rather as a mediator to assist the parties. And that if there's any communications, you're going to keep them confidential, but they're not covered by any sort of solicitor-client privilege. It seems to me that the answer about consent is a lawyer who's acting as mediator should be saying, I'm not going to be giving any sort of legal advice here at all. Rather, I'm attempting to bring the parties together. If you want legal advice, you go see your lawyer. Or if you're unrepresented, understand that I can't give you any legal advice. And particularly if you're going into a mediation with somebody who's unrepresented, you might want to make sure that that's spelled out clearly in advance and that everybody's signed off on that. They make the point as well that if, as part of a mediation process, you are drafting something and you're providing it to the parties, you should be well advised to ask the parties to go and get independent legal representation. Although this applies to mediators, I would suggest that the same language would apply in cases where you're acting as an arbitrator. Jeremy, supervision, over to you.
Yeah, I won't spend a lot of time on this, but 6.1 on the section on supervision says a lawyer has complete professional responsibility for all businesses entrusted to him or her and must directly supervise staff and assistants to whom the lawyer delegates particular tasks and functions. And there's quite a number of commentaries, and I would bring your attention maybe to 6.1 sorry, I'm not in the commentaries, but 6.13 further down says a lawyer must not permit a non-lawyer to do a whole list of tasks there. So it might be useful for those who have staff to give a review to that commentary sometime. And I think the general takeaway from the commentaries here is that is to be, I guess, careful what work is delegated to non-lawyers in the office. And it is interesting as well. I would point out 6.1-2 also says a non-lawyer for purposes of this section does not include a student at law or an articling student. So I'd keep that in mind as well. And as well, I'll point out 6.1 sub 4 says that without the approval of the lawyer's governing body, a lawyer must not retain, occupy space with, use the services of, or employ in any capacity a person who has been disbarred or is suspended or has undertaken not to practice. So I thought that was kind of an interesting one to point out. And as well, 6.1-5 talks about electronic registration of documents. This would be probably in like land titles systems and things of that nature. So it has some guidelines there for who can be permitted to access those services, and also talks about not disclosing passwords and things like that. So that's kind of an interesting section probably for people that do real estate and things like that probably. And the next section is about students. And it talks about the duties of a principal to provide a student with meaningful training and exposure to work that will provide the student with knowledge and experience of the practical aspects of the law. If you have a student, I think there's probably requirements in other legislation or other rules of the Law Society that deal with that, but do note it is in the commentary here in the rules. And as well, we'll go to 6.3, harassment and discrimination. And this section in particular is undergoing quite a rehaul. And there is new language coming, which is going to add quite substantially to this section. So definitely keep an eye out about that. There will probably be some publicity about that. And that was, I believe we had distributed those for comment at some point, but I don't think we got a whole lot of commentary on that.
We did, Jeremy. We actually distributed it twice, and we got a modicum of comment. And what's happening with that is the Federation of Law Societies is now having a final review of it. And I would expect that come the fall, we'll have some new language around that we'll be rolling out. And there will be lots of information coming out to the members about that.
Yeah. Yeah, and I think I think that's more the commentary. I think the rule stays kind of the same, but the commentaries are definitely quite expanded. And if you are interested in that, like I said, we did send it out a couple times, but if you are interested, I can certainly send that to anyone that reaches out, and definitely keep in mind that that's coming though. And I think that's over to you, Glenn.
All right, thanks. Responsibility to the society and the profession generally. 7.1-1, you must respond promptly to any communications from the Law Society. If the Law Society writes to you and says, we have some questions about your law firm self-report, you would do well to respond to that and respond quickly. Because the next step, of course, if you don't respond, is to engage to turn it into a disciplinary matter, and nobody wants that. 7.1-2, you are obliged to promptly meet your financial obligations in relation to your practice, including payments of your insurance fees. The Law Society is concerned if you're unable to meet your liabilities generally as they become due and you end up becoming bankrupt. But that's not necessarily going to be a prohibition against you practicing if your bankruptcy has nothing to do with your practice. The Law Society becomes even more concerned, however, if you're not paying the rent for your office space or paying your staff or making any of the payments that you're required to make in relation to the practice of law. 713 is a duty to report. This becomes a little bit distasteful, but remember, this is an obligation that's imposed upon all of us. Unless to do so would be unlawful or would involve a breach of solicitor-client privilege, you must report to the Law Society misappropriation or misapplication of trust monies, the abandonment of a law practice, participation in criminal activity, conduct that raises a substantial question as to whether another lawyer's honesty, trustworthy, or competency as a lawyer, conduct that raises a substantial question about the lawyer's capacity to provide professional services, and any situation in which a lawyer's clients are likely to be materially prejudiced. That's not just you, that's anybody else as well. And we've had situations in this jurisdiction where it's been an open secret that there are members of the bar who are not competent to practice. However, nobody saw fit to mention that to the Law Society. And when the Law Society eventually found out and took action, the commentary we got back was, why did it take you so long? Everybody knew this was going on. If you see a situation, alert the Law Society. It doesn't necessarily mean that we're going to be taking disciplinary action. There's all kinds of other mechanisms we can employ, formal and informal. But our focus here, remember, is to serve the public. And if one lawyer isn't serving their clients, then we're all not serving our clients, and we all get painted with that brush. There's a mention about professional assistance programs in the commentary. And finally, 714, a lawyer must encourage a client who has a claim or complaint against an apparently dishonest lawyer to report the facts to the society as soon as reasonably practical. 7.2, responsibility to lawyers and others. Again, the overarching commentary here is around civility, being civil with everybody you deal with. Avoid criticizing other members of the bar, because that in and of itself could perhaps be a violation of the code. No matter what you might think of the way I practice, keep those comments to yourself and certainly don't share them with your client. 7.2-4 talks about avoiding sending correspondence that's abusive to other lawyers. 7.2-5 talks about responding with reasonable promptness to all letters you receive from other lawyers. Again, in the top 3 situations that we get complaints about, one of them is from other lawyers saying, I can't get lawyer A to respond to me. And if they're not responding to another lawyer, likely they're not responding to their clients as well. That causes our antennae to go up. 7.2.8 talks about being representing a corporation and not dealing with employees of the corporation. 7.2.9 talks about dealing with self-represented or unrepresented people, the obligation to urge them to get independent legal representation, to make sure they understand that you're not representing them in whatever proceedings is going on, and to make it clear to them that you're acting solely and exclusively on behalf of your client. 7.2.10 happens occasionally. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably ought to know that the document was inadvertently sent out must promptly notify the sender. You accidentally get said something that ought not to be sent to you. What should you do? You should notify the sender and then take the document and run it through the shredder. And then finally, 7.2.11 talks about undertakings. You can't give undertakings that you cannot fulfill. Trust conditions as part of undertakings must be clear and unambiguous. You shouldn't accept trust conditions that are unreasonable or that can't be fulfilled. And a reminder as well that if you can't, for whatever reason, fulfill a trust condition, your obligation is to return all the documents that came under trust to the person who sent them to you with an explanation about why you can't fulfill the trust condition. And then there's a little bit of language around what you do in terms of modifying trust conditions. 7.3, Jeremy.
Yeah, 7.3 is outside interest in the practice of law. And it says a lawyer engaged in another profession, business, or occupation concurrently with the practice of law must not allow such outside interest to jeopardize the lawyer's professional integrity, independence, or competence. In the commentaries at number 2 talks about the potential conflict issue, to watch for that. And as well, 7.3 sub 2 says a lawyer must not allow involvement in an outside interest to impair the exercise of the lawyer's independent judgment on behalf of a client. And at commentary 1, they note that outside interests could include any number of things. And I would note as well at commentary 2 under 7.3 sub 2, it says that ethical, when the outside interest is not related to legal services being performed for clients, ethical considerations will usually not arise unless the lawyer's conduct might bring the lawyer or the profession into disrepute or impair the lawyer's competence, such as if the outside interest might occupy so much time that client's interests would suffer because of inattention or lack of preparation, which maybe goes back to a little bit of what Glenn was just talking about there as well. And 7.4 talks about the lawyer in public office, and that lawyer, even though maybe they're not acting as a lawyer, is held to the same standard of conduct. And partly this is because that lawyer is in such a public position that it's seen as that the legal profession may be more readily brought into disrepute by a failure to observe the ethical standards. So I thought that was kind of interesting. And as well, I would note commentary 3 notes that lawyers holding public office are subject to the provisions of section 3.4 dealing with conflicts. So that's something to be mindful of if you're in that position. And 7.51 talks about public appearances and public statements and speaking to the media. And notably, I would point to commentary 2 under that says a lawyer's duty to a client demands that the lawyer must first be satisfied that any communication is in the best interest of the client and within the scope of the retainer. And commentary 3 as well says public communications about a client's affairs should not be used for the purpose of publicizing the lawyer, and should be free from any suggestion that a lawyer's real purpose is self-promotion. So I would highlight those sections there. And as well, it is noted at commentary 7 as well to keep in mind when you're speaking to the media that you generally have no control over any editing or any context in which the statement may appear. So definitely keep that in mind. And as well, 7.52 talks about the fact that a lawyer must not communicate information to the media or make public statements about a matter before a tribunal if the lawyer ought to know that the statement might prejudice a party's right to a fair trial or hearing. So definitely keep that in mind if you're in an ongoing case. And I think we're passing over to Glenn for the final few sections here.
Yeah, this is the home stretch. Thanks, Jeremy. We got another comment, and it was a very good one. And this is a very 2020 comment, and it pertains to lawyers getting emails. Some lawyers when they email opposing counsel, will copy their clients. And we've had situations in this jurisdiction where the other lawyer, upon receiving that, will hit reply all and reply to the lawyer, which then sends the communication to that lawyer's client as well. That's inappropriate. You ought not to be doing it. When the situation arose here, we spoke to the lawyer who was doing that. The lawyer said, my practice is just to hit reply all always. And it was suggested to that lawyer that that might not be the best practice. And that in fact, the better practice would be just simply to reply to whoever sent you the email. You can get yourself in all kinds of trouble if you're going to be hitting reply all, because then you're communicating with somebody else's client directly. And as Jeremy flagged for you earlier, that's a practice that is frowned upon by the code. So if your general practice in responding to emails is to hit reply all, you might want to rethink that practice. And thank you for that suggestion. Preventing unauthorized practice, 7.6, a lawyer must assist in preventing the unauthorized practice of law. That's something that many of us are quite good at. If there's a sniff that someone who isn't licensed to practice in this jurisdiction is practicing, we get at one, sometimes two, sometimes more queries. And we appreciate that. What happens is we typically send them a letter that says, we're not a member of the mobility agreement. You can't practice here unless you're a member. You don't appear to be a member. Why don't you become a member? Typically, the response is, yes, we'll become a member, or we'll take out a rack, and they go forth and sin no more. 7.7 talks about retired judges returning to practice. That's never happened here, and I don't want to spend any time on it, but I do want to tell you that it is a big deal in other jurisdictions. And you may remember recently a situation involving members of the federal cabinet, where it appeared that every retired member of the Supreme Court of Canada who was still alive was weighing in on that particular dispute for a variety of parties. That's triggered some focus on providing some more fulsome provisions in the Code of Conduct around this, and we can expect that something's going to be rolling out, although not particularly quickly, around that. The final section is with respect to errors and omissions. If you make a mistake, tell the client that you made a mistake. Tell the clients what happened, but don't admit any form of liability. At the same time as you're doing that, and probably even before you're doing that, notify the insurer. Because if you don't notify the insurer and you instead start taking steps to rectify, you may in fact have invalidated your insurance. And that's going to cause you a whole world of problems. If you notify the insurer first, the insurer may very well appoint counsel, and counsel may instruct you what to say to your client so that you can protect the client's interest, but at the same time, protect your interests. The commentary makes the point that if you make an error, you are obliged contractually by the terms of the insurance policy to report to your insurer. You're also obliged by the provisions of the rules of the Law Society to report to the Law Society. 782 beefs that up, talks about giving prompt notice of the circumstances that give rise to a claim to an insurer. You are not judged. There are no black marks that go against you if you make a report to the insurer about a claim or a potential claim. The only people that know that are the Law Society, the insurer, and you. If there is found to be an error, remember again, we talked about the fact that being a competent lawyer doesn't mean you're a perfect lawyer. If you did something wrong and the insurer ends up paying out, the insurer ends up paying out. Again, there's no black mark against you. There are certain ramifications if you end up having more than 3 claims against you, but in this jurisdiction, we haven't had anybody who's had even 1 claim against them. So the prudence suggests that if you have any doubt, report. You're never going to get in trouble for reporting something that amounts to nothing. You're going to get in all kinds of trouble if you don't report something that does end up amounting to something. 783 is the requirement that you cooperate with the insurer and the insurer's counsel. And 784 talks about claims where for whatever reason you may not be indemnified by the insurance policy. And if that's the case, you must expeditiously deal with the claim and not take any unfair advantage or do anything that would defeat or impair the client's claim. And if liability is clear and for whatever reason the insurer isn't covering the whole of the claim, you've got a duty to pay the balance. And that would be our not so brief review of the code of conduct. I'm looking at the clock and see that we were able to make the 2-hour mark. So those of you that were looking for 2 hours in ethics, you now have it. Jeremy, are you okay to stay on the line for a bit if anybody's got any questions?
Sure.
All right, if there are any questions, just pump them into the chat. If there are not, thank you all very much and enjoy the rest of your afternoon. And Jeremy and I'll stay around for a couple minutes. Okay, Jeremy, let's assume that we're not going to get any questions. All right, did you get your hot water tank in yet, or are you still waiting?
Just like right at 12 o'clock, literally, like everything was good.
Timing is everything. All right.
Yeah.
I'll leave you. There were.
Yeah, thanks, Glenn.
No, that worked well. That worked well. There were 43 people who showed up. That's good.
There were 40. Okay, good. I thought, was there in person too, or no?
There was one person who was here and he left halfway through. There were supposed to be 2, but there was only 1 and he left halfway through. So.
Yeah, and I work with him, so he's going to hear about it.
Glenn,
I say nothing. I say nothing.
Glenn, I have one question, and it's kind of a unique one. In the code where it says the duty when you're a prosecutor, and I've always interpreted that as being you were in the criminal courts prosecuting, but I've heard some say that it applies to people who are representing a regulator in a regulatory regime.
Interesting.
Because I mean, different standards of proof, different, imbalance in the sense of the power of the state versus the individual.
Right, right. I've never thought about that, Craig. Jeremy, what do you think? I mean, my inclination would be the same as yours, but maybe it's a worthwhile question to ask.
Yeah, it's funny. I've always, and I don't think prosecutors define anywhere, but I would have always thought the criminal context as well, right?
Yeah. Has there been any chatter about that in Alberta, Craig?
Well, I asked that question because I had a disciplinary hearing that went well over 40 days, and the person was a self-represented professional, but also a lawyer. And he kept throwing that up on the table, that there were these duties under the code and that I was violating all these duties. So, I mean, in the end, let's just say it didn't end up well for that person. And the Court of Appeal agreed, and the Supreme Court of Canada said no thank you. So but it was something that's always kind of sat in the back of my mind. And
the courts chose not to weigh in on that.
No,
that was not an issue for them. Yeah.
No.
So there's a code of conduct group that meets quarterly. I will throw that question out to them and see if I can get an answer and share it with you.
Yeah,
it's a good question.
Well, and it's one that, because the prosecutor is not defined, that's why I would say, well, I guess, but it would be moving into the realm of the criminal law and all the principles that apply. You know, it's kind of like in, we look at Groya, right? And what the Supreme Court of Canada and resolute advocacy. And I think it has to be read in the scope of that was a criminal prosecution, and that because someone's jeopardy was at the heart of it, that's why resolute advocacy was a defense. But I don't think that behavior would pass muster in a civil context or a tribunal proceeding.
Right, it's kind of like Abramovich too, where they've taken the Jordan principle and are trying to lay it on top of the law society. Yeah. I'll pose the question. That's a good one.
Yeah, the scuttlebutt I have, because one of the lawyers in our office now, who was legal counsel at the Lost Society of Saskatchewan, says Abrametz is anticipated by the end of the month.
Oh, because the last I heard when I asked from Saskatchewan was they said October. Okay, well, good.
Well, no, it's been argued, but
Yeah,
so
no, they thought the decision was going to come out in October. I don't know where they got that from, but
okay, well then, and maybe the word I got was wrong, but it you know, the biggest question is, are they going to go back to the principles in Blanco,
yeah,
where what is actual material prejudice versus it's weighing heavily on my soul that Abrametz was able to use.
yeah. Well, and interestingly too, I guess it came out at the oral hearing that when someone asked Abrametz's counsel why they were delaying, they said that, well, there was an advantage to that. And they admitted that there was an advantage. It allowed him to continue to practice. So,
Yeah. Anyways,
Okay.
gentlemen, thank you. I appreciate your stuff.
All right.
Yeah,
Thanks,
thank you.
Greg.
Bye.
Bye, everybody.
Yeah.